Who on the other side?
Dr. Saraf will be appearing in this case, Malad.
Is he here? Yes.
My Lord, I'm there.
Yes, sir.
My Lord, the issue which you also formulated in the last order as to whether, my Lord, the person claiming exemption under section
Order dated.
My Lord, just one time, my Lord.
You filed your returns.
My Lord, I filed the return, my Lord. So the lordship raised the issue as to whether the return filing is compulsory or not.
No, but have you filed the returns?
No, I have not filed the return.
Because you took leave. As is recorded in the order of 12th of October, you took leave to file the return without prejudice.
No, that was the issue was there, but your lordship was to raise the first.
No, that's all right, but you have not filed the return.
I think my Lord, return not.
Returns have not been filed.
No, ma'am.
Very well. What is the challenge in the petition, Dr. Saraf?
Well, this is the challenge in the assessment order passed under section 148.
Let us see the order and then you proceed your own.
My Lord. You'll also find the order at page 37 minutes.
37.
Lecture 3.
So you have a PAN card.
Yes, ma'am.
PAN card is here.
You have a PAN card. And let us see the operative part of the order.
Well, this deals with the different about the different incomes. But mainly they have said that since the income tax return has not been filed, and thereby the exemption will not be available. You'll also may kindly see the order.
Yes. Just take us to the operative part, Dr. Saraf.
Well, you'll also see page 41. One of the, I'm submitting the also. Page 41.
41.
Just 3 paragraphs above para 7.
So one is that your eligibility for exemption of income can be considered only on filing your return and other along with your supporting evidence to justify your claim. That is number one. Then account on unexplained credit, money, undisclosed short-term mutual funds. So basically they ask you to file a return, nothing else. Now you tell us that, you show us that the filing of the return is also exempted. Give us the Income Tax Act.
Well, we'll also see one more paragraph. We'll also make up the
Yes, which paragraph?
The next document, which you're also reading at page 41.
Without filing, you are personally liable to forego your, so it is clearly asked to file your return under 148.
You are personally responsible to forego your claim under the income tax.
Yes.
So the view which has been taken by the income tax officer is that,
Sorry, your voice is not very clear.
My Lord.
Yes.
I am clear now.
Yes.
So the view which has been taken by the income tax authority is that, in case income tax return is not filed, then the person will forego the claim of exemption under section 1026 of the income tax act.
Very good. Let us see the law now. Let us see the act.
My Lord. I am listening for us. Let me first take section 10 of the act.
Sorry?
Section 10 of the act. Section 10 of the
Is there a second connection open in your chamber?
No, I don't think so.
If there are two connections, then that interferes. It can be outside, there's no problem.
I'm just checking.
It can be outside, that's not a problem, but if it's inside,
My lord. Otherwise, I take from my pick the laptop. Maybe there's a problem here.
because we are not being able to follow what you're saying.
Now, I'm clear.
Yes, much better.
My lord. In the outside below, they were the juniors were below.
Yes, they can, yes.
My lord. My lord, occupancy section 10 below.
710. Section 10. Yes.
My lord.
Yes.
In computing the total income of a person, total income of a previous year of any person, any income falling within any of the following claims shall be included.
Yes.
So it says below, in computing the total income of any previous year of any person, any income falling under the different subsections shall not be included. So the total income, while computing the total income falling under section 1026 will not be included.
Just ask if the problem is at our end. Call Vincent.
But give me 2 minutes to change my from my to the laptop.
Yes.
Section 5 below. Section 5 below.
Yes, carry on.
It says scope of total income. Subject to the provisions of this Act, the total income of any previous year of any person,
You're reading?
resident includes all income.
Where are you reading? Section?
Section 5.
5.
Section 5.
Scope of total income.
Am I now audible, my lord?
Yes, you're much better now.
My lord, I changed from iPad to the laptop, my lord.
Yes.
Now it says, my lord, subject to the provisions of this Act, the total income of a previous year of a person who is a resident includes all income from whatever source derived from which is received so and so. So it says of the total income, my lord. You're asking me, my lord? Subject to the provisions of this Act, the total income of a person. So, in fact, we are concerned with the total income.
Yes.
Now, if you lastly looks to section 224,
Yes.
24 speaks of the income, and it says that income includes, and there are various heads of the income which will be related to the income. Now the main concern is the total income.
Yes.
Which is section 245.
225.
245.
245.
245. Yes.
It says total income means the total income, total amount of income referred to in section 5.
Yes.
So it says total income means the total amount of income referred to in section 5, computed in the manner laid down in the Act.
Yes.
Total income means the amount of income referred to in section 5 and computed in the manner laid down in the Act. Now section 10 says, that the income which are enumerated in different subsections will not be included while computing the total income.
Just a second, let us see.
Section 10, you also see.
In computing the total income, any income falling within shall not be included. Yes. Excludes, section 10 excludes the matters, the matters indicated in the clauses from total income. Yes.
So 1026 income also,
Yes.
is excluded from the total income.
Very good.
Now, if you also look into section 139, which is the submission of the returns,
Section
139.
139. Yes.
It says, subsection 1, every person being a company or a firm or being a person other than company or a firm, if his total income or the total income of any other person, respect of which is accessible under the Act during the previous year, exceeded the maximum amount which is not chargeable to income tax, shall on or before the due date furnish a return of income or the income of such other person during the previous year in the prescribed form and verified in the prescribed manner and setting for such particulars as may be prescribed.
Just if his total income or the total income of any person in respect of which he is accessible under this Act exceeded the maximum amount which is not chargeable to income tax, total income exceeded, shall on or before the due date furnish a return of the income or the income of such other person during the previous year. Yes.
So, if my total income exceeds the maximum limit which is the exempted, then I am liable to file the return. Now,
yes.
in my case, if the conjoined reading of section 224, 245, 5 and 10 is so, my lord, that total income does not include the income which is enumerated in the section 1026 of the Income Tax Act. If the total income does not include the income under section 1026 of the Income Tax Act, my lord, and that is to be excluded from
Now-
the total income.
Now,
My lord.
Mr. Dr. Saraf,
My lord.
whether or not
My lord.
you're allowed to the exemption or not is a matter that has to be decided, that cannot be unilaterally decided by you.
Absolutely correct, my lord. I'm not on that, my lord. Absolutely not, my lord. You're
So
absolutely
therefore,
correct, my lord.
so therefore, total income will exclude it.
My lord.
Total income you will not be required, maybe in the usual course you may not be required to file it. But when you're seeking exemption, or when they find that your total income is huge, and as to whether you're entitled to the exemption or not becomes an issue, then you have to indicate the basis of your income, and that may involve the filing of a return.
My lord, I will submit in this way, my lord. Absolutely, my lord, the practical difficulties of the department, or I may say, my lord, that in what way, if you think that we can ask a question to myself, my lord, in what way the department will determine whether the income is exempted or not. That issue is there, my lord. I'm not saying at all, my lord. I am on the issue, my lord, now that the Act says the person will file the return only when his total income exceeds the
Yes,
exempted income.
but as to whether that total income which is liable to be exempted for the purpose of 2026 is really what he is entitled to exemption or not is a matter which cannot be decided unilaterally by the SSE. The SSE may claim, but ultimately the decision has to be of the department.
I will just try to answer the question, my lord.
Yes.
To the best of my ability, my lord. My lord, under Income Tax Act, there are two types of exemptions. One exemption is that, my lord, income falls in the total income, and thereafter exemption is granted. And certain incomes which are not at all doesn't come within the purview of total income at all. Now you'll also see chapter 6A.
Deductions in respect of certain incomes.
Now, these are the incomes which the person may claim deduction from the total income. Now, this will also find there are various exemptions in this chapter. Now, in this case, my lord.
Just a second, chapter 6A. Come to section 66.
66, my lord. Hello. 66 minutes. In computing the total income of an SSC, there shall be included all income on which no income tax is payable under Chapter 7.
Chapter 7.
Chapter 7, you know.
So that is not really relevant.
Not relevant. You lost 6A, my lord, once if you lost it, take it, my lord.
6A.
A, my lord. A.
Yes.
I may read the one, my lord.
Yes.
In computing the total income of an SSC, there shall be allowed from the gross total income, in accordance with the subject to the provisions of this chapter, the deductions specified in section 80C to 80U. Now, this is, my lord, from the total income, the deductions are to be made. Now, this can only be claimed while submitting the returns, because the gross total income exceeds the taxable income, and thereafter the deductions are there. But in a case where the gross total income does not include the income at all, then section 139 says the return is not to be submitted. Now, your lordship's query is very much relevant. I'm not disputing at all, my lord, that department will, my lord, come to know that whether exempted or not. But, my lord, in my humble submission, my lord, the taxing statute, as your lordship is well aware, my lord, I need not tell your lordship had dealt with and more experience than my lord, than me, my lord. The taxing statute's interpretation is altogether different than the interpretation which is to be given.
No. That old principle is now changed.
Well,
in fact, there are recent Supreme Court judgments which say that there is no principle that taxing statute has to be construed to the benefit of the SSE.
No, I'm not saying benefitless. I'm not saying at all, my lord.
No, sir. There are two things.
My lord.
We are not laying down immediately as to whether or not you have to file a return.
My lord.
You need not file a return. If you think your total income is not accessible to tax,
my lord,
in accordance with the provisions of the Act, you need not file a return. Very good.
My lord.
But if the department says that we have to inspect whether your apparent income, not total income, where your apparent income exceeds the tax threshold limit,
my lord,
and that apparent income is liable to be exempted,
my lord,
then you perforce must file a return and satisfy the department that you are entitled to the exemption.
My lord, on that also I will try to satisfy lordship, Lord.
Yes.
Lord, under the Income Tax Act, the assessment, when it is escape assessment, there is a provision in section 147 of the Act.
Sorry, just come again.
When the assessing authority has reason to believe that any income has escaped assessment,
yes,
then he can go to section 147.
147, yes.
Now, 147 of the Income Tax Act,
147 presupposes a return. But when there is no return, when you are invoking the 139, you are invoking 1026, then you are in great dangerous territory. If you are relying on 147, then you presuppose return is filed, in which return you claim exemption, and then they go under 147. 147 will not come into play unless there is a return filed under 137.
With due respect, to your lordship, 147 does not say, that the return, only when the return is there, then only 147.
Let us look from 137 onwards.
147.
137 onwards. Let us look at 137 onwards.
137, Lord.
This is now gone. So we come to 139.
139.
139 is the return of income. And all of this procedure for assessment is contained in a chapter which begins at 139. So you cannot say 147 does not have reference to 139. Let us see 147. There are several provisions inbuilt in 147 and 148 which make it obvious that it's only the return which is being considered. Come to 147.
May I read below?
Yes.
If any income chargeable to tax in the case of an SSC has escaped the provisions of section has escaped assessment. Well, we're asking first, that any income chargeable to tax in the case of an SSC has escaped assessment for the assessment year, the assessing officer may, subject to the provisions section 148 to 153, assess or reassess such income or recompute the loss or depreciation allowance or any other allowance or deduction for such assessment year, thereafter referred to in section 148, 158, referred to in the relevant assessment year. First of all, the assessing officer must come to the conclusion, my lord, that any income chargeable to tax has escaped assessment. Now we'll also further see, my lord. The explanation, my lord. The explanation. For the purpose of assessment,
Yes.
or reassessment or recomputation under this section, the assessing officer may assess or reassess the income in respect of any issue which has escaped assessment, and such issue comes to the notice subsequently in the course of the proceeding under this section, irrespective of the fact that the provision section 148A has not been complied. So if something comes into the notice after reopening, that can also be considered. Now we'll also see 148.
Yes.
Before making the assessment, reassessment or recomputation under section 147 and subject to the provision section 148A, the assessing officer shall serve a notice along with a copy of the order passed, if required, under clause D of section 148A, requiring him to furnish return within a period of 3 months from the end of the month to which the notice is issued, or such further period as may be allowed by the assessing officer on the basis of an application in this regard by the SSC, a return of income or income of any person in respect of which he is assessable under the Act in the previous year corresponding to the relevant assessment year, the prescribed form and prescribed manner, and setting forth any such particulars as may prescribe, and the provisions of this Act shall so far as may be apply accordingly, as if such returns were a return required to be furnished under section 139. So the return which you will be asking will be as if such return was a return required to be furnished under section 139.
Yes.
If a return is not required to be filed under section 139.
No. That's the deeming provision. Once the assessing officer, have reason to believe that income has escaped assessment, then for the purpose of all three, assessment, reassessment or recomputation. Assessment means no returns previously filed and were assessed. Reassessment means returns previously filed but wrongly assessed. Recomputation means wrongly calculated, income chargeable to tax. So, and the deeming provision in 139 is, even if you were otherwise exempted,
My lord.
But upon receiving that notice, you're deemed to file a return as if you were required to comply with 139.
My lordship is absolutely correct. My lord, subject to what your lordship has said, my lord. My lord, my efforts are only to, so far the legal issue is concerned, my lord, I am trying to assist your lordship only, my lord.
No, let us read the provision. Let us read the provision.
Hello, yes. Further, see, my lord, if your lordship looks into the third provision, my lord.
Now, generally what will happen, Dr. Saraf, generally what will happen is, there is an income tax return filed, then an assessment order is made under 143, and thereafter the assessing officer has reason to believe that some income has escaped being charged. Then he issues a notice. Reasons to believe is a different chapter. We'll keep the reasons to believe differently. But what can he do? He can ordinarily, if it was confined to reassessment or recomputation, then it would have been all right. But over here the word assessment is also there, which means that not only if you had filed a return, but even if you had not filed a return, considering that you were not liable to file a return under 139, but still the assessing officer has reason to believe some income escaped assessment, then upon his notice you are required to comply as if 139 applies to you.
I will submit in this way, subject to the case of an SSC where the assessing officer has reason to believe that though he was chargeable to income tax but had not submitted the return, he may invoke the provision section 147 and 148 of the Income Tax Act and ask him to submit the return. There is no dispute about it. In case the assessment has been completed, and if he has reason to believe that income has escaped assessment, he can invoke section 147 and 148 and ask him to file a fresh return.
Correct.
And there is no dispute about it.
So therefore, what is the harm when the income tax officer over here has filed, assessing officer has requested him to file a return? How is it illegal? How can it be challenged?
The assessing officer must have reason to believe that any income has escaped assessment. The lordship is well aware, that 147 and 148 powers are not for the purpose of investigation. Whether an income is chargeable to tax or not, that investigation is not permitted under section 147 and 148 of the Income Tax Act. If the income tax officer has materials to show that this is the income which is chargeable to tax, time of is chargeable to tax, but had not been charged to tax, he can issue notice under section 147 and take recourse to 148 and take recourse to 147 of the Income Tax Act. Now, in this case, my lord, if your lordship take the trouble of looking at why the 147 notice was issued, if your lordship just take the trouble, my lord.
Yes.
This is the affidavit of opposition filed by the department, my lord.
No, the department thing is not really relevant. We will have to find out everything from the order itself.
Well, this is the affidavit, my lord, the reasons which have been recorded. This is filed by the affidavit of opposition. Order is there, not there's order copy. Case 79, my lord.
Page 79.
In fact, I have same thing in the page 38. I'm sorry, page 38 of the petition also.
Page 38 of the
petition.
Yes.
In the beginning, you also find the reasons recorded in the statement 48.2 of the Income Tax Act is reproduced below.
Yes.
May I read below?
Just wait for Justice Digdo.
My lord.
Yes, in this case?
In this case, no return of income was filed for the assessment year 2013-14. Information gathered reveals that the SSC has paid rupees so-and-so for purchase of mutual fund and a high value banking transaction deposit of rupees so-and-so totaling rupees so-and-so. Since so-and-so has not filed return of income for the so-and-so, you'll also kindly note it, since so-and-so has not filed return of income for so-and-so, I have reason to believe that the income of the SSC chargeable to tax has escaped assessment to the tune of rupees so-and-so. Lord, how he can say that the income has escaped assessment on the basis of that?
That's all right. That's all right. That's all right. That's something we will not interfere with.
No,
No, sir, that's something we will not interfere with.
When
you unilaterally do not furnish information and you claim exemption of a huge amount of 10 crores which is being exempted under 1026, we will not go into those.
But this income is exempted.
The reason to believe has to be qualitatively different when you filed a return and qualitatively different when you've not filed a return. When you filed a return, there's something to go by. When you have not filed a return, reason to believe will be given much more latitude.
Well, with due respect to your Lordship, that if this is interpreted that I am not liable to submit the return as per section 139 of the Income Tax Act, and 147 he doesn't say that any income has escaped assessment, and only for the purpose that you will not file the return, and I will reopen make the reassessment notice. In my humble
all that he wants to do, the entire procedure and the provision have to be read in the context of the facts. All that he wants to do is to ascertain whether you are entitled to the exemption that you've claimed or not. And that you cannot get away. No.
That means you want to make the verification.
Exactly. But and you cannot escape that.
I will submit to your Lordship one judgment of the Apex Court that this is not permissible. If your Lordship permit me, I am just, your Lordship will lay down the law.
No. The difficulty is I am not very conversant with tax law. So you can take me round in circles and play with me. So that I am very aware of.
The queries which your Lordship is raising, nobody can say that your Lordship is not well conversant with income tax law. In fact, I think we are not conversant, and Lordship is much more conversant. Your Lordship is 71-1 SCC 453.
71-1.
I've given the copy to the colleague at the Archival.
Yes.
Para 4. That you also got him,
Yes.
May I read him, if it's possible. In his report, the income tax officer does not set out any reasons for coming to the conclusion this is a fit case for issue of notice under section 140.
Sorry, you're reading paragraph 4.
4,
From the SSC online.
Page 456.
SSC online.
Yes, we've got SCC itself.
No, this is online. Normally, it differs at time. The paragraph and the.
I've given the copy of the scan copy yesterday.
This is the same.
I'm sorry, my lord. In fact, that's why I said
this is.
My lord?
Yes. It is 1971-1 SCC 453. 1971-1 SCC 453. Yes.
Am I audible, my lord?
Yes.
My lord, paragraph 2 ends with the income tax officer ward A.
Paragraph 2. The SSC is having construction contracts under railways as well government. Partnership firm for the assessment of
So I would like to look into paragraph 4, my lord, in fact.
paragraph 4, yes, section 147.
It starts with, my lord, in his report.
No, section 140, paragraph 4 is section 147 of the deals with income escaping assessment. Another paragraph 4, yes, in his report.
My lord. And in his report, the income tax officer does not set out any reasons for coming to the conclusion that this is a fit case to issue notice under section 148. The material that appeared before him for issuing notice under 148 is not mentioned in the report. In his report, he vaguely refers to certain communications received from the CIT Bihar and Odisha. He does not mention the facts contained in those communications. All that he says is that from these communications, it appears that these persons, allocators, are name lenders and the transactions are bogus. He has not come even to the prima facie conclusion that the transactions which he referred to are not genuine transactions. He appears to have only a vague feeling that they may be bogus transactions. Such a conclusion does not fulfill the requirement of section 151(2). What that provision requires is that he must give reasons for issuing a notice under section 148. In other words, he must have a prima facie ground before him for taking action under section 148. Further, his report mentions, hence proper investigation regarding these loans is necessary. In other words, his conclusion is that there is a case for investigating as to the truth of the alleged transaction. That is not the same thing as saying there are reasons to issue notice under section 148. Before issuing notice under section 148, the income tax officer must have either reasons to believe that by reasons of the omission or failure on the part of the SSC to make a return under section 139 or assessment year to the income tax officer, or to disclose fully and truly all material facts necessary for assessment for that year, income chargeable to tax had escaped assessment for that, or alternatively, notwithstanding that there has been no omission or failure as mentioned above on the part of the SSC, the income tax officer, in consequence of the information in position, reason to believe that income to chargeable to tax has escaped assessment for the assessment year. Unless the income tax officer had the requirements of clause A and B of section 147 are satisfied, the income tax officer has no jurisdiction to issue notice under section 148. From the report submitted by the income tax officer to the commissioner, it is clear that he could not have reasons to believe that by reason of the SSC's omission to disclose fully and material facts necessary for the assessment for the year in question.
Dr. Saraf, the second part after the first thing is complied with in this case. Second thing, it is not necessary that every notice issued under 147 that it will end in income being actually discovered which escaped assessment.
No, I'm not saying that.
So there are cases where he may have reason to believe, but when the assessment, reassessment or recomputation is made, he finds that no income escaped assessment.
Absolutely.
Now, if that is the case, then what you are reading this to be, judgment to imply that unless there is a prima facie satisfaction that income actually escaped assessment. Now over here we are in a situation which is quite different from the one in the 71 case. In the 71 case, the partnership firm SSC had filed a return. CIT Bihar informed the assessing officer that it's a mere name lender, these are bogus transactions, and therefore you take action. Now, without doing anything, based on that notice and without any investigation, he says he has reason to believe. Now, that reason to believe over there is not substantiated by any material other than the unilateral allegation of the CITBR. Of course, that is not prima facie satisfaction. But when you are an SSE who shows that you have an income of several crores and you have claimed exemption, then the latitude available to the assessing officer for his having any reason to believe will be much wider. You might be able to demonstrate to him that all of that income is exempted. Then you go away. He cannot take any action. But you cannot stultify the process by saying that I have not filed any return, this is my constitutional right, I will not file a return. We will read down the requirement of reason to believe and the effect of reason to believe in a case where you are seeking exemption under 1026 and you have never not filed a return. We will read down. None of the cases that you cite on 147 will the reason to believe, what is attributed to the expression reason to believe will not apply in a case where you are seeking exemption under 1026 and have not filed a return.
Well, with due respect to your lordship, certainly can pass, read down, your lordship can do any order, your lordship is after all.
No, Dr. Saraf, we have to be alive to the situation. We have to be alive to the situation. What is happening is that you are abusing your exemption.
Well,
there are rampant cases of abuse of exemption. There are several people, and this is not an apprehension that I am expressing in 2023. This apprehension was expressed in a 1976 judgment. What is happening over here is that some traders or some businessmen, they are running their business entities in the names of servants who are entitled to exemption, but the actual owners of the business are those persons who are in control.
Maybe.
Is that what 1026 gives exemption to?
Well, absolutely correct. Your lordship is absolutely correct. There is no dispute about it. But what I was trying to submit before lordship, the same feelings which your lordship has got it, the same feelings are with me also. There is no doubt about it, my lord. But my submission before lordship is that, when the legislature, parliament, while enacting the law, my lord, consciously has made a provision that these persons are not to submit the returns. My lord, in my humble submission, by making or a provision, my lord, or by reading down and making it liable, my lord, your lordship, in my humble submission, with due respect to your lordship, my lord, that will amount to, my lord, the interfering with the provisions of the act.
No. We have to see the purpose of it. The purpose of it is to ensure that the general standard of a class of persons who have been deprived or who were in difficult circumstances are uplifted. Now that will not apply to a person with tens of crores of rupees as income.
My lord, it may be 100 crores also, my lord, that your lordship well knows that income tax 110 crores, 100 crores, I am not on that amount, my lord. My submission before lordship is that, my lord, that the legislative intent and the purpose is only to be gathered from the words of the act.
Absolutely, nothing else.
Now,
but when you say reason to believe, reason to believe has a connotation.
My lord.
There's a history of, you could fill up this room with the number of judgments on reason to believe.
Right. So I submit it to my lord. Now two things have come now, my lord. First, whether an SSC who is entitled to exemption to Section 26 is liable to submit the return or not. First. Secondly, when 148 notice is issued, whether he is liable to submit the return or not.
Yes.
These are the two things that have come
Yes.
up.
The second one. First, we agree with you. He is not liable to file a return. On your argument. Now, once he is in receipt of a notice under 147, read with 148, is he then liable? Can he say, no, I will not file a return?
Only at least half the race, my lord, according to me, my lord, once 139, I could try to convince your lordship, my lord, then half the race I won.
Absolutely.
Now coming to the question of 147, your lordship is absolutely correct, my lord. I will not dispute at all, my lord, that the intention, the purpose behind, and the legislature and the people are taking, some people, my lord,
undue advantage. Now, you see, as much as you ensure that the benefit is obtained by the beneficiaries, you must also ensure that the benefit is not abused by persons not intended to be conferred that benefit.
If I would have
That is an equal thing. Both run parallelly. You can't say for the benefit just shut your eyes. No.
But in fact, your lordship's observation, the legislature should take into consideration, in fact, according to me, and if I would have been any role to play in the framing the legislation, I would have been the first person to make the provisions which your lordship is suggesting in the act.
No, Dr. Saraf, till such time that we are able to do that, we can't legislate. We have to be pragmatic and interpret the law, because the ultimate intention is benefit has to be conferred to a class of persons. Now, while that is there, simultaneously runs a parallel consideration that the benefit should not be abused by persons not intended to be conferred that benefit. See, all of the staff sitting over here, all of the staff, everyone, they have income from one source, which is the salary that they earn. So it's clearly a 1026 income that they are in a scheduled tribe area, they are members of a scheduled tribe, and the income derived is from that area. So none of them is liable. If they were to receive a notice and that is the only income, the notice would be quashed at the issuing stage. But if a person has 20 different heads of income and claims that by virtue of 1026, none of these accretions, I'm not calling them income, none of these financial accretions will amount to total income, then the department is liable to scrutinize the same. And the only way to do is 147, resort to the word assessment which it gives over there, and then the deeming provision of 139 will come into play. You file your return, you're clean, they will have to say, all right, you're clean. But we cannot stultify the process of, looking into your income.
Well, I take a note of your lordship's observation that if really somebody else who is taking advantage of the provisions of the act, as your lordship correctly said, that some people are doing the business in the name
maybe
of...
We don't know. We don't want to cast any aspersion. We will take it that we will take over here that the SSC is absolutely clean. But we have to be alive to the possibility. And what the department has said is they've raised the issue of possibility.
Well, I'm not saying about the petitioner, my lord. I'm not saying about the scheduled caste and scheduled tribe, not all, my lord. When we find, my lord, some other persons are taking advantage of the provisions section 1026 of the Income Tax Act,
yes,
it also pinches us also.
Absolutely.
We are paying 40% tax, and that person who is not a scheduled caste and scheduled tribe, he is taking advantage of section 1026.
Absolutely.
So there is no doubt about it, my lord. It is not so that, my lord, by paying 40% tax myself, another person who is not entitled to is taking benefit of. There is no doubt about it, my lord. In the Income Tax Act, there are so many loopholes are there, my lord.
Absolutely.
And according to me, these loopholes are, my lord, intentionally kept the loopholes, my lord. That is not it's not so that they are not aware. Everybody is aware, my lord, what are the loopholes in the Act.
Dr. Saraf, we can't say anything about the legislature. We have to show respect. But is there any, with the greatest of respect and humility, is there any quality discussion that goes on in Parliament or any assembly these days? Is there any quality discussion on matters of importance?
This has to be passed in 2 minutes, my lord. These things are to be passed in 2 minutes. This does not need any discussion.
In fact, I had struck down an act in Tamil Nadu and I had asked for the legislative records, and I found that the entire thing was passed in 3 minutes. The actual time taken was 2 minutes 57 seconds.
You also see the finance bill which has been passed. It took 1.5 minutes. The finance bill has been passed, and so many amendments are there. Nobody is aware what are the amendments. It has been passed. What can be done, my lord? This is the state of affairs now. So I will take your lordship to, if your lordship permit me, my lord, although your lordship has taken a particular view, but it's my duty to place before lordship some decisions.
Yes,
yes. Thereafter,
yes.
I've given one compilation to your lordship, my lord.
Yes.
And your Lordship may kindly take, my Lord, page 62.
Page 52.
62, my Lord.
62. So your first decision is on reason to believe.
No, this is an interpretation I'm giving, my Lord.
Then 62.
And relevant part at page 74.
62 is 1975 to SCC 736. You have them, Dr. Modika? Yes.
And Lordship, I will take your Lordship to page 74, my Lord.
Page
74.
74.
Para 28. Has my Lord Justice Dindo got it, my Lord?
Yes.
My Lord. May I read, my Lord? Or I may start from page 20, para 27, my Lord, at page 7.
Yes.
The construction which we have placed on these provisions of 1953 Act does no violence to the similar principles which in Cape Brandy Syndicate was expressed by Rowland J. In the taxing statute, one has to look at what is clearly stated. There is no room for any intendment. There is no equity about a tax. There is no presumption as to tax. Nothing is to be read in. Nothing is to be implied. One can only look fairly at the language used. This principle was approved and adopted by this court in several decisions and so on and so on and so. The principle is variously expressed by saying that in fiscal statute one must have regard to the letter of the law and not to the spirit of the law, that the subject cannot be taxed by inference or analogy, that in a taxing statute there is no governing principle to look at and one has to simply go on the act, that while construing the taxing statute, it is not the function of the court to give to the words used a strained or unnatural meaning, and that the subject can be taxed only.
What provision? What was the provision that fell for consideration?
My Lord.
What was the provision that fell for consideration over here?
15A, my Lord, you lost me, see. 15 at para 17 below. Or I may take the facts below at para 3.
The facts you'll get is with paragraph 9.
My Lord.
The only question with which we are concerned in this appeal is whether the orders of reassessment and assessment passed by the respondent number 1 are without jurisdiction by reason of the fact that the SSC firm was dissolved prior to the date on which those orders were passed.
My Lord. My Lord.
Now you come to the last slide. This court has taken a view that if under a statute a dissolved firm cannot be assessed to sales tax, it does not make a difference whether the proceeding was initiated before or after the dissolution. Thus the question for decision is whether a dissolved firm can be assessed or reassessed under the Bombay Sales Tax Act. Now if there is a provision which says that a dissolved firm cannot be, then there is no question of intendment.
But in this case also.
In this case, there is nothing like that. There is nothing like that. You are seeking, you are in a fiscal statute, there is a cardinal principle that when you seek an exemption, then you must clearly fall within the strict words of the exemption or not be entitled to it.
Well, in my understanding, this is not an exemption. This is not computing. This will not be included at all.
Yes, you are claiming exemption, that the total income, not the total income, that the financial accretion during the relevant period would not be included as part of total income. Since that would not be included as part of total income, there was no obligation on your part to file a return, and there can be nothing else to it. The question is whether or not the entirety of the financial accretion was liable to be exempted under 1026 is not a decision that you can take unilaterally.
But my only submission that on the point of return only, income tax return only. I'm not submitting on the anything whether it's not the. I'm just placing few paragraphs if you Lordship permit me.
So the interpretation given over here, we have to confine to the context.
Absolutely.
If the context says that a dissolved firm cannot be proceeded against or no assessment or reassessment can be made, that's not the same thing. That principle will not apply in our present case.
My number submission, with due respect, as so far as I've been able to understand from section 147. The section 147 only in the case of any income which has escaped assessment chargeable to tax, the assessing officer must come to conclusion that income has escaped or not charged with tax. That in 147, 148 is not for the purpose of making investigation or verification, in my respectful submission. For the purpose of that, he cannot initiate 147. Now, in this case, he has not come to the conclusion that this mutual fund or this income are chargeable tax or not in section 26. He is only saying that since you have not filed the return, and thereby I want to verify. In my submission, not referring on section 1971 Supreme Court, 148 does not empower the assessing authority only to issue notice for the purpose of verification.
Let us forget the provisions, Mr. Let's come to common sense. All right? They say that law is not logic, but law cannot be illogical also. Now, I have a huge income.
I fully agree. Common sense.
Now, what is the provision? What is the provision under which an assessing officer finding a possible assessee having a huge income seeking the benefit of exemption may be up to something wrong? What is the provision under which he will proceed?
There is no provision. And according to me, if there is a lacuna, it is for legislature to plug up. If the lacuna
No. So we will look at the alternative. The alternative, if the alternative is that such a criminal has to be allowed to go scot-free, then we will do violence with the statute and will interpret it otherwise.
Para 28, Para 28.
This principle will not apply over here, clearly.
No. For my satisfaction, I may place some.
No, you can read the entirety of it, but the principle will not apply. The statute says that a dissolved firm cannot be accessible to sales tax, will not be accessible to sales tax. Now, the moment they proceed against a dissolved firm, that's wrong. The reasons for proceeding don't matter.
Well, I'm only in the ratio of the decision, para 28, May I read more?
We look at it, but we dissolved firm, paragraph 9. Yes.
Para 28, the principles that stated has hardly ever been doubted, but it is necessary in the application of the principles to remember that though the benefit of ambiguity in the taxing provision must go to the subject and the taxing provision must receive a strict construction, that is not the same thing as saying a taxing institution should not receive a reasonable construction. If the statute contains a lacuna or loophole,
we are not saying that. We are not saying that. We are not suggesting that the statute contains a loophole or a lacuna. We are saying that a reasonable construction must be given to the statute. And that reasonable construction is in the use of the word assessment in 147.
Right. may I place some few paragraphs below? It is not the function of the court to plug the restraint construction in reference to the proposed intention of the legislature. The legislature must then step in to resolve the ambiguity, and so long it does not so, the taxpayer will get the benefit of that ambiguity. But equally, the courts ought not to hunt out ambiguities by an unnatural construction of a taxing statute. Whether the statute, even the taxing statute, contains an ambiguity has to be defined by applying the normal construction of the so-and-so, as observed by so-and-so. In the cases have decided that taxing statutes are to be construed with strictness, and that no payment is to be extracted from the subject which is not clearly and unequivocally required by the Act of Parliament, or may probably mean that little more than this, that inasmuch as there are no any prior liability or as per paragraph 29. The true implication of the principle is that a taxing statute must be construed strictly is often misunderstood and principally unjustified from well-known principle in so-and-so, greater than the reluctance to seek the invitation. In that famous passage, marked by Hepburn of Frederick Rowland J. said, there is no equity about the tax, there is no presumption to tax, there is no equity about tax in the sense that a provision by which tax imposed has to be construed strictly regardless of the hardship that such a construction may cause either to the treasury or to the taxpayer. If the subject falls squarely within the letter of the law, he must be taxed, however inequitable the consequences may appear to the judicial mind. If the revenue seeking the tax cannot bring the subject within the letter of law, the subject is free, no matter that such a construction may cause serious prejudice to the revenue. In other words, though what is called equitable construction may be admissible related to other statutes, other provisions, taxing statutes, such a construction is not so and so. Now, Your Lordship may, I may take Your Lordship one or two decisions.
Just 1 second, Dr. Saraf. Even in a taxing statute, there are certain provisions which are machinery provisions and certain provisions which are charging provisions.
Absolutely correct.
Now, the machinery provisions can be interpreted so as to give effect to the charging provisions.
Absolutely correct.
The charging provisions cannot be widened, but the machinery provision can be read in consonance with the charging provision.
No dispute about it.
Now, over here, 147, 1026 are all machinery provisions.
With due respect, 147 is not a machinery provision, my lord, because 147 is the melody that has been held, my lord, that this is a provision.
147 is the process by which you go to discover. It's a machinery, it may be a machinery provision. The chargeable provision will be chargeable to tax.
The charging provision, you are also aware that there is only one charging provision in there, and the charging provision remains in all the acts, one charging provision. But
let us ask you something directly. Do you have anything direct on this proposition, on the one that we are dealing? You are going to several other instances which may not be comparable instance, as in the present case.
Well, directly which your lordship is asking, my lord, it will be difficult to be, my lord, the proposition which your lordship has asked me, my lord, to
because we are only on 147. Why has the word assessment been used in 147?
My lord, one assessment has been made, my lord, subject to my capability, my lord. My lord, 147 says of the assessment that in a case of a person who was liable to pay the taxes but had not filed the return and escaped assessment, then a assessing officer 147 he can make the assessment also.
Correct.
But
now
147.
Why will your client not fit that bill over here?
Well, I would say that if the assessing officer would have come to a conclusion that this income, whatever is there, is not an income arising out of by the scheduled tribe in the scheduled tribe area and is not exempted, prima facie, I'm saying prima facie, my lord, I can, if the primacy could have come to the conclusion, Lord, there was no dispute at all. But he had not come to the conclusion prima facie also. He simply said that you have not submitted the return, thereby, my lord, you 148 proceeding. In my respect permission, this is not permissible at all. A person, by issuing notice under 148, at least he must come to the conclusion that this is not an income which is exempted in the section 126. And thereby he is simply saying that this is the amount and you have not submitted the return. The basic reason that
there, Dr. Saraf, you're possibly right to some extent over there, but there we want to say that when there is no material to go by, then we will read down that reason to believe. In a case of an assessment, when nothing is there, we will read down the reason to believe, but the law will take its own course. The reason to believe in case of reassessment and recomputation naturally will be a different kettle of fish from reason to believe when there is no assessment. What you say is right. For instance, he has information that he derived income for hiring machinery, let us say in Tamil Nadu, which is not a specified area, so his income comes from a non-specified area, and he says that you have done this. That would have been ideal reason to believe that some income has escaped assessment. But he says that I have no information as to where all this has come from, and I have reason to believe that it may have escaped assessment, and I want to verify.
But if this should have been said, my lord, if this should have been said, which your lordship is observing, my lord, I think there was no difficulty at all. But with due respect, my lord, what your lordship has observed, if that would have been there in the reason to believe, there was no difficulty at all. He is simply saying that since you have not filed the return, my lord, that cannot be, in my humble submission, a reason for reopening the assessment. Your lordship also see the, my lord, the implication of this. If this is allowed to the assessing officer, my lord, in all the cases, he will issue notice that I want to verify. That is not permissible, my lord, under 147. In my humble submission, my lord, if this is equally, my lord, for the SSC also, and equally, your lordship, you see the department also. There are persons on the tax evaders in the SSCs. Similarly, there are persons who are, my lord, creating the troubles and, my lord, taking actions which are not permissible in the law. That will give them a handle to issue notices to everybody that I want to verify. And that, according to me, 147 and 148 interpretation may have, in my humble submission.
That is why we are saying we will limit it to cases where no return has been filed, and not extend it to where return has been filed.
I must admit, the assessing officer may seek clarification, may issue notice that this is the return, this is the income. We kindly explain. First, you explain to this that this is the income where from you got it. But in my humble submission, by issuing a notice on the 148, at the first instance, he cannot insist the assessee to file a return which he is not liable to file return. If he finds thereafter after verification that yes, this is income which he prima facie, he finds that yes, this is not exempt under section 1026, he may ask him to submit the return. But simply on the basis of the, otherwise what will happen, in my humble submission, the very purpose will be frustrated. This is a heavy case. I can understand, my lord. This is a heavy case. These notices will be issued to everyone. These notices will be issued in a regular course to everyone. And the purpose of incorporating such a provision for the benefit of the scheduled tribes, scheduled castes, scheduled tribes in the scheduled area will itself be frustrated. So last you will find that in a mechanical way, the computerized notices will go to everyone, 148. And that, according to me, my lord, will frustrate the very purpose for which this such type of provision has been
passed. Now, under what provision has the order been passed?
Well, 147, 148.
147, 148, the order has been passed. So, will you be happy if we set aside the order, and then we can say that the assessing officer may take fresh steps in accordance with law after indicating what reasons to believe may imply?
Subject to
but of course, it will then be governed by the new 148. It will no longer be governed by the old 148.
Well, absolutely. Here also, he has applied a new one. Here also, he has applied new one. Well, my submission for also be that, first of all, he must verify that whether this income is eligible or not, and not on the ground that he has not submitted the return thereafter, thereby he will not be eligible. That should not be the ground.
There is Dr. Mozika, there is some basis in this submission that, we have to also keep in mind the consequence of this. Now, if the assessing officer has so much authority that without anything he will say, I have reason to believe, then he will defeat 1026 by issuing notice to every eligible person.
My lord, in the notice, it says, my lord,
Reason to believe.
information gathered reveals that the SSC has paid rupees 7 crore 74 lakh for purchase of mutual fund.
Just a second.
My lord, page 38, I'm reading, my lord.
Page
38
38.
of the writ petition.
I have not filed income. I have reason to believe that the income of the SSC charges income tax to the tune of so and so as mentioned above. There is reason to believe that such as a record by either omission or failure, part of SSC disposed fully to assessment. Category 1-3 of civil instruction, clarification dated so and so.
You'll also see the second paragraph, the second line.
My lord, the reference is to purchase of mutual fund to the tune of 7 crore 74 lakh rupees and high value banking transactions deposits of rupees 30 lakh totaling to rupees 8 crore 5 lakh 57,000.
Yes.
My lord, in my humble submission, this is sufficient indication, my lord.
What is sufficient indication?
That the value of transaction is 8 crore rupees, my lord.
Value of transaction is not the issue over here, Dr. Bozika. For instance, let us say I am exempt. I have 100 crore.
My lord, if I may submit from the beginning, my lord.
Yes.
I just wanted to respond to what Dr. Saraf has said, my lord. My lord, if I may have a look at 139 once again, my lord. Well, I don't know whether the lordship is the recent version of the Act. Income
Yes,
Tax Act,
we have.
my lord.
We have a 2021 edition.
21 is the same, you know.
My lord, section 139, there is a 7th proviso, my lord.
139. There is
The 7th proviso, my lord. It starts with provided also that a person referred to in clause B.
just a second. Provided that a person referred to in clause B.
who is not required to furnish a return under this subsection and who during the previous year.
Just a second. And residing in such area will be specified. So there is another one. Provided the person being provided also that nothing contained fourth proviso. Then
After that, my lord, provided every person being an individual or Hindu undivided family.
Yes,
And
after that.
my lord, after that, my lord.
provided also that a person referred to in clause B
Who is not required to furnish a return under this subsection and who during the previous year has deposited an amount or aggregate of the amounts exceeding rupees 1 crore in one or more current accounts maintained with the banking company or a cooperative bank, has incurred expenditure of an amount or aggregate of the amounts exceeding 2 lakh rupees for himself or any other person for travel to a foreign country, or has incurred expenditure of an amount or aggregate of the amounts exceeding 1 lakh rupees towards consumption of electricity, or fulfills such other condition as may be prescribed, my lord. Now, the conditions prescribed are, so basically 3 conditions are in the Act itself, my lord.
and then the notification referred to over there.
My lord, the 4 conditions are by way of notifications, my lord. So in my humble submission, they are not exempted from,
Filing return.
if they fall in any of the 7 categories, my lord, they are not exempted from filing of return, my lord.
Absolutely correct. There is no dispute at all. I'm not disputing at all. If he falls in
Now, my lord,
any of
if
the
you come back to the section 139, my lord, the first part, every person being a company or a firm, so company or firm, irrespective of the income, my lord, are bound to file return. Clause B, my lord, being a person other than a company or firm, if his total income or the total income of any other person exceeds 2.5 lakh rupees as it stands today, my lord. So there is an exclusion to clause B, my lord, but by way of 7th proviso. So 3 provisions are in the Act, in the 7th proviso, my lord, and 4 provisions are in the notification by amendment of Rule 12AB of the income tax rules.
Now, if I am liable to file a return
my lord,
and have not filed a return,
my lord,
what is the consequence? Will the consequence be under 147?
This is under Section 142, my lord. Section 142.
My lord, only one aspect is there, my lord, because there is every year there are amendments to the Income Tax Act, my lord. It appears, my lord, the assessment year in question here is
13, 14.
13, 14, 14, 15, 15, and 16, 17, my lord. I tried to get what was the exact position of 7th proviso at that point of time, my lord.
This is inserted, you can see.
Because it seems, my lord, earlier, pre-2006, if somebody had a telephone connection, my lord, you remember we were in this, maybe in college or school, my lord, at that time, and somebody at foreign travel had a credit card.
Or a car.
Or a car, my lord, motor vehicle, other than the year to file return. So, because those things were too small, my lord, so those were discontinued with 2006, my lord, and new provisions were brought in from 2006.
So, if that was the case, the assessing officer, if has a condition that you see you have fulfilled these conditions and you should file the return, he can issue a notice. He is not doing that, there is no questions or he is not issuing notice on that.
Then why did you resort to 147? You could have straight away said that you should file a return.
My lord, it appears that these amendments have come subsequently, my lord.
May have come subsequently, may have been there. Let us take it for your benefit. If I have not filed a return, what will you say? You say file a return. Or you will say that the entire income I'll take it and I'll charge it.
My lord, the notice issued to the assessee in this case, he was asked to file return, my lord, under 147.
No, that after
But this 147 has been resorted to, reason to believe.
My lord, only because I could not get the exact picture of what was the position of law, what was the statutory provision.
Get that. Ask Dr. Saraf. They know all this by heart. And they can play the fool with us, people who don't know.
So, my lord, in my humble submission, the correct position, my lord, will be that if you take that this provision, 7th proviso was not there at that point of time.
Very good. We will then read everything down, we will get the order out, and we'll say all that it requires is for him to file a return.
But for future, my lord, from now onwards, some observation from your lordship that those who fall in these 7 categories, my lord, under the 7th proviso, they must file return, my lord.
Yes, we'll observe that. But then failure to file a return will not result in a 147 notice.
142 notice.
Will result in a 142 notice. Or adverse inference being drawn and tax and penalty being imposed. If 142 provides for that.
So, my lord, that is a mechanism. It appears that much clarity has come now, my lord, that though under 139 clause B, they may be exempted, my lord, from filing a return, but because of the 7th proviso, my lord, if they fall in any of the 7 categories, must file return, my lord.
And we'll take it simply as a way to request to file a return, where 147 was overzealousness, and we'll read it down to be just a 142 return.
My lord.
Yes. Lordship may just see 142, my lord.
Yes.
1 second, my lord, for the time being, my lord. For the purpose of making an assessment under this Act, the assessing officer may serve on the person who has made a return under Section 115D or 139, or in those cases where time allowed under Section 1 or Section 39 for furnishing return expired in notice, requiring him to date to file return specified, where such person had not made a return within the time allowed under Section 1 so, or before the end of the relevant assessment year, to furnish a return of income of such person accessible under the Act in the prescribed form, prescribed manner, in prescribed form, setting for such particular so, provided where such notice has been issued in the subsection 1 for the purpose after the end of the relevant assessment year, commencing on or after this so to assessing person who has not made the return within the time allowed under Section 139, or before the end of the disseminate, any such notice shall be deemed to have been served in accordance with the provisions of so-and-so, provided notice is served for the purpose of clarification to the person, income so-and-so, to a produce or to so-and-so.
What is the limitation?
Limitation. So, my lord, my submission is that 142.1 notice in respect of the assessment of 2006-7 cannot be issued now in 2023.
What is the limitation? What is the limitation?
My lord, I've just paid out.
Why don't you get a department person who will be able to tell you this, get someone to instruct you, and because we'll be pronouncing conclusively on this, you should have a department person just go through it, that we don't make a mistake that this law was not there and we read that. That will be very embarrassing, and we are surrendering. Both before Dr. Sarafa knew that we are not so conversant with income tax laws. So he can, banana circles around his tail for the entire day.
But what I was submitting, for this case, if your lordship set the orders for assessment and direct assessment officer that the verification of the questions which he raised, he may ask the verification of those questions from the SSC first, and if he comes to the conclusion that no, these are not exempted, then he may direct him to submit the return. If that exercise is undertaken, in my humble submission, first of all, let him come to the conclusion that yes, these incomes are not taxable. Not only on the ground that the return has not been filed, so this will not be allowed. That should not be the way or the ground for rejecting the exemption. Let him verify that whether these are exempted in Section 1020.
We'll keep in mind. That's a fair suggestion. We'll keep in mind. Let's make a note of this.
But there's one more aspect, my lord, to the entire matter. In one of the cases decided by the Tripura High Court, my lord, a full bench of the Tripura High Court, my lord, in my compilation I've given, my lord, this is at flag F. My lord, there is a provision 197 in the Income Tax Act, which talks about an exemption certificate issued by the Income Tax Department, my lord. Now, it appears that is how the Tripura High Court has interpreted that, my lord. A tribal, if he is not filing return, my lord, he must obtain an exemption certificate from the Income Tax Department, my lord. And for obtaining income tax exemption certificate, he has to supply all kind of whatever information is required by the department, my lord. So once he obtains the exemption
certificate, that has not gone before the Supreme Court.
It appears it has not gone to Supreme Court.
But we will not be so harsh. Entire 1026 will be wiped out if you ask for exemption.
Because it appears, my lord, the idea is that because this is
the case where 10 crores, 8 crores from every village, to some places.
Yes.
People try people going to the income tax department and obtaining certificate. That will be, the very purpose will be frustrated.
We will not be so harsh in saying that kind of an exemption certificate is. Just confine yourself to this.
Yes.
Confine yourself to this. He's made a good suggestion.
Well.
Just see, there's no trick in that. That ultimately, when we set aside this, because of limitation, nothing can happen. We also don't expect him to do that because he will also guide us in the right direction. That is his.
So basically, what I have to ascertain, my lord, what was the provision of law applicable at that point of time, and in view of those provisions, whether 142 was applicable or 147.
And what he's suggesting is that he has given reason to believe. I don't know. That's why I have reason to believe.
Well.
Whereas he should ask for those details, and upon the details, verifying the details, he can say, I have reason to believe, and then it can go on. That is what he's saying.
Well. Filing of the returns should not be a ground for rejecting the claim, rather than filing of the return.
Absolutely. Absolutely.
That is only, in my humble submission. Instead of, this will take care of all the situations.
Very good. Very good. That's a fair suggestion. That's a fair suggestion. We must make sure that while we are trying to arrest a mischief, that we don't create further mischief.
Well.
I'm looking at these people. I should not expose them to, unnecessary something which they are not required to do. Yes. They have single source of income paid by government, that's the salary. no other source of income. If we provide for a general rule that they will also have to go for an exemption certificate, it will be onerous.
But if they have high value transactions, my lord, and if they fall in any of the
That's a
seven
different
categories, my
thing.
lord.
That's a different thing.
Well, when the service tax notices were issued on the lawyers,
Yes.
and they were asked to get themselves registered, a hue and cry was made that why we should get us themselves also registered. These petitions were filed and everything. How the department will verify whether this was professional income or rental income? Every lawyer started crying that no registration, no registration. And ultimately no registration was done. So Rasim, see the mirror. When it comes to others, then we say that you come. So, my lord, my humble submission is that, my lord, it should be a reasonable custom.
When should we keep it?
Day after tomorrow.
Day after tomorrow, we will be able to. Day after tomorrow, Dr. Bozika suggests, is that all right with you, Dr. Saraf?
Rasim, just half a minute. Yes, it is.
10th.
Oh, yeah. But I can do it, below.
Wait, day after tomorrow. After the matter is heard substantially, at the request of the department, the same is adjourned to day after tomorrow's day.
I'm highly obliged to Rasim.
Thank you. Please guide us appropriately, because so that we don't make a fool of ourselves also.
No, my lord, I will never, my lord, I will be this way that if the department also and the SSC also know the rest, and department also gets the lawful revenue.
Yes.
Deeply. Full.
Thank you.
My lord, conviction under 302. And my lord, if I may, with lordship's permission today.
Item number 3.
You are so confident that you start the matter even
Well,
though it's called.
actually, lordship, I wanted to seek lordship's permission. In fact, my lord, in this case, my back is already against the wall. There is a confession. So, my lord, if lordship may grant me some time today, my lord.
When?
Well, fortnight, just a fortnight. Then I'll argue this matter, my lord.
Let the matter appear a fortnight hence as sought by the appellant. Yes.